Hi Kim, it's great that you come here all the way from Canada. Executive Director of the Canadian Association of the Fry Society and part-time law lecturer at the Ottawa Law School. Yeah, it'd be interesting to discuss some of the subjects that you teach there, because it's going to be really relevant today around our discussion. So can you just tell me a bit about what you do, like what your organisation do in relation to the women you work with that have been victims or survivors of domestic and family violence?
Sure. Yeah. Well, it's great to be here. Thanks for having me. And I teach two courses at the law school. One's prison law, but the one probably most relevant to this discussion is the defending battered women on trial, which we teach for senior level law students so that they can, usually they've had criminal law and sexual assault law beforehand, and then we focus on women who have experienced and survived violence. And then within the organization, I'm with the Canadian Association of Elizabeth Fry Societies. We work with women who are marginalized, victimized, criminalized, and institutionalized. And we, in particular women who are victimized, we work with women who have experienced violence and who have used force themselves in a reactive way. So we first started, there was a court case in Canada called the Lavalee decision. It was in 1990. The Supreme Court of Canada looked at a situation where an Indigenous woman who was living with a man who was incredibly violent had, there were people over that night, and so there were witnesses to this man's violence against her, Ms. Lavalee, and after the people left, she shot him. And the evidence that she provided was that she had actually, he had threatened to kill her and then thrown his gun at her and said, you may as well shoot me, because if you don't, I'm coming back and killing you when everybody's gone. She shot him in the back of the head. And so the big question was it self-defense? Because she had shot him as he was leaving the room in the back of the head, and not as he was attacking her. And so, but the court found that in fact it was self-defense, because now they found that she was suffering from a syndrome, which was a problem. They used an expert to testify that she had suffered from battered women syndrome. But the court looked at it and said really what applied was self-defense. And so after the decision in her case, what we did was look at all of the cases of women who were jailed at the time for killing abusive partners who were in prison, as well as some who had already been released, and realized there were patterns to what had happened to them, that they had either not been believed, or the lawyers had said it wasn't relevant because they hadn't killed them in the midst of the attack. So anyway, we reviewed those cases and then called on the government to do a review. It took a number of years. We worked with a number of women's groups, anti-violence groups in particular. Our Canadian Association of Sexual Assault Centers came on side and said that we should be freeing these women. They should not be jailed for that. And we also had a number of academics, lawyers in particular, do an analysis of the battered women syndrome and argue the problem with battered women syndrome is that it stereotypes women, that it pathologizes women, it characterizes as unreasonable the women's response to violence instead of the unreasonable violence that women experience. And so we started a campaign to also reject the notion of battered women's syndrome as an analysis, because what we really want is the defenses to be recognized as having to understand how women react to violence. And so, for instance, self-defense was developed at a time when women had no rights, when women were the property of the men who were their fathers or who they married. And they had no separate entitlement to rights. And so the law of self-defense developed then when women, it wasn't presumed women should be defending themselves or would be entitled to defend themselves from anyone. Men were permitted, the rule of thumb comes from that time, men were permitted to beat their wives and their children as long as they didn't use a weapon or instrument, it was said, that was thicker than the width of their thumb. And so the law of self-defense developed around how men fight, particularly in bar rooms, and so it was really a defense that was applied in barroom brawl situations where men were fighting, force for force, responding to each other in reasonably timely way, and if unreasonable force was used, then they wouldn't be able to use self-defense. Well, when you're talking about battered women and children, if they fight back in the midst of an attack, they usually end up dead, and so the law had to the law hasn't caught up yet, but we argued that the law is unfair. In fact, as recently as last year in a case called the Ryan case, we argued that it is unconscionable in this day and age when we've had in our country 3 decades of charter protection, of so-called equality for women, that women still aren't equal, and that the defenses are defined around how men operate in the world, and women cannot benefit from them. And then in that case, it was a woman, Nicole Doucette, as she is known now. She had married Michael Ryan. He had threatened her for many years. She had left him, so what everybody says is, why didn't she leave? She did leave. He kept threatening her, including breaking into her home, threatening her with guns, raping her, threatening to kill her and their daughter, and showing her where he was planning to bury them so they wouldn't be found, showing up at her place of work. But when she went to court, she was charged because even though she called police and victim services several times, they didn't intervene to assist her. They kept saying it was a civil matter, they couldn't do anything, that she would have to call when he was in full flight, basically, and you know how often that's not possible. And so her father actually suggested they hire someone to kill Michael Ryan. So when she tried to do that, then the very same police that refused to assist her set up a sting operation, and a police officer posed as a hitman. She tried to hire him, and then she was arrested and charged with conspiracy to commit murder. When it went to court, her lawyer argued, and he couldn't argue self-defense because nothing actually happened to Michael Ryan. He wasn't harmed in any way. And so they argued duress, and the jury who heard all of the evidence acquitted, or the court, I should say, the judge who heard all the evidence acquitted her. It went to the Nova Scotia Court of Appeal, which is one of our provinces. It went to the senior court there. She was acquitted. They upheld, 3 judges upheld the acquittal. It then went to our Supreme Court of Canada, where then the prosecutors tried to say that in fact she should have argued self-defense, duress was the wrong defense, and almost trying to retry her at that time, which of course an appeal at that level is ultimately supposed to be on a point of law.
Well, and the evidence that's already been before the court, not new evidence.
Yeah, that's right, and the evidence was accepted that she lived under a reign of terror. And Supreme Court of Canada, though, with one judge dissenting, agreed that she shouldn't have been acquitted on the basis of duress. That was the wrong defense. But in an unprecedented situation said, but we're going to issue a stay of proceedings. So it's not an acquittal. So it's not saying she was justified in protecting herself and her daughter, but saying it was their term was disquieting to see how quickly the police acted to intervene to protect Michael Ryan and did nothing to protect her. And so we talk about that as essentially deputizing women, saying there's a withdrawal of state protection or the lack of availability of state protection, and yet the minute women act to defend themselves and their children or their children, so the state deputizes them, says it's your job to protect yourself and your children, it's your job to leave, it's your job to get the protection, it's your job to make sure you're safe. The minute they act to do something to protect themselves, if they can be, they will be criminalized. And so we have the jails full of women who, some of whom have tried to protect themselves, some have actually have, including some who have used lethal force, and so they've killed the abuser. And so our argument is the laws need to catch up with and recognize the reality of women's lives, not in a way that pathologizes them, the way battered women's syndrome has, but in a way that recognizes, hang on, to be equal doesn't mean to act the same way. That if a woman responds as she's being attacked, she's likely to end up dead because she's often different size, different capacity. And the very little research that's been done on some of this, 2 things are emerging. One, that since we have actually had police officers laying charges, the backlash has been they lay charges with a vengeance, and usually against the women as well. So if a woman calls the police because she's being attacked, she has more than 50% chance of also being charged. So that's one thing that's terrible that's happened. And there's also a likelihood that he won't be charged. We have lots of instances where women call the police because they're being attacked. The police arrive, the man may have been, if he's ever been charged before, he knows to say nothing often, and he may say, well, she attacked me, and if he's got any kind of defensive scratches or anything, then there's very high likelihood she'll be charged as well. So we have what we call either dual charging, counter charging, or only charging the women. And many of the women will plead guilty because they're trying to get out, to get back to kids, or trying to maintain a family home or whatever. And so we end up seeing women disproportionately in prison. And we don't see the men's behavior really being challenged in the way it should be. I mean, there are a few cases, in fact, where the police have said things like, women are now becoming equally violent as men. And
and same here. And it's the same situation where we see so many women criminalised. Well, the fight here, as it was in Canada, for protection of women against violence, and we know that the majority that have violence perpetrated against them are women by men. However, what we've done is degendered the law. So our domestic violence and family violence protection laws, if you like, have been degendered. So they're not targeted for women. So what we have now is what I would call a backlash. And we see so many women, particularly Aboriginal women, in prison where first the police will go in and there's an incident, and so a dispute, and they'll put a domestic violence order on both, husband, wife, partners. And then if there's another dispute, the police come back. He has been violent to her, she's reacted to the violence and either hit him back or used a weapon or whatever, and predominantly Aboriginal women in North Queensland. So, and then what we see is the police actually charging her for the breach of the domestic violence order and then the violent offence. And so what we have is the black and white statistics, if you like, that women, particularly Aboriginal women, are more violent now than ever before, but it's taken out of context because it's the way that the law has been degendered. And it's like I agree about the label battered women syndrome, but what's happened here in this state is there was a law reform process with a report and about looking at this area of women being abused and reacting. We enacted here, the Parliament enacted a Section 304 capital B, which is, it's not a battered woman's defence, it's a battered person's defence. And so what we see is, once again, the degendering of violence against women. So do you have protections there, like in relation to DV orders and things like that?
Yeah, there are civil, so you can get protection orders that are either civil or criminal. And so those exist and they're used, but they're not always used because they're often ineffective. Because, as I mentioned, in Nicole Ryan's case, or Nicole Bissett's case, she tried to do that and they still wouldn't come. And so, what you're describing is very similar to what we've seen, where exactly the degendering of violence against women and calling it domestic violence even hides the fact that it's very clearly who's committing most of the violence. And that doesn't mean women are incapable of being violent. Of course they are. But there's been very few studies, or there have been some studies of police behavior, and certainly one of the things we study in the course is that a fellow named George Rogakos in Canada has done some research on police attitudes to violence against women, and particularly racialized women. And what he found was that even when you have more women police officers, the culture of policing is such that they conform. And so if they go to a house and a woman isn't hysterical crying, then they don't believe she's actually been abused. If she has in any way used defensive force, they don't believe she's been abused. And then the flip happens when you go to court. If she's hysterical crying, she's seen as not credible. If she's too calm, she's seen as not credible. So, have this horribly stereotypical ideas of what a battered woman is that gets reinforced by things like the syndrome analysis, which says basically she was a good mother, good wife, took the violence, just kept on going, kept the house clean, did all this, and then suddenly snapped and couldn't take the violence anymore and was violent towards him, which is ludicrous. And so it problematizes the woman's, I would say, predictable and more normalized response to violence, instead of problematizing her reasonable response to violence, instead of problematizing his unreasonable violence against her. And so then the other studies that have been done have looked at, same thing has happened. They're saying in Manitoba in particular, the police start saying, women are becoming, especially Aboriginal women, as violent or more violent than men. And look, here's this group this year, the equal number of men and women, or more women, were charged with assault and particularly armed assault with a weapon than were men. So we encouraged some of the academics to do research, and what they found is actually they just had to peel back not very far, just open the police file and see that in the cases of women, particularly Indigenous women, the weapons that were used were hairbrush, pan, pot, plate, something like that. Occasionally, if there was a more serious weapon used, it would be the man's gun or the kitchen knife, not some weapon they had gone out and purchased. And in most cases, the men, if it was men who were injured by the woman, didn't even require hospital. It didn't require any medical attention. Whereas when you open the files of the men who had been charged with assault, particularly assault with a weapon, many of them weren't charged with assault with a weapon because the weapons they used were their fists, choking women, holding them down, trying to suffocate, that sort of thing, punching them. And if they did use a weapon, it was their own guns or their own knives or hunting equipment, that sort of thing. And in most cases, the women were hospitalized, not just required medical attention, but sometimes hospitalized or nearly dead and these were just assault charges. And so a vastly different scenario quickly unfolds just by opening up the police files, and yet they were perpetrating this myth and this propaganda and this really misogynist attitudes towards women as becoming more and more violent, and equating it to women's equality and saying, look, the more equal women get, the more violent they get. And in fact, it's completely not true. We know that in fact, in Canada, there's a group called the Women We Honor Committee, I think it's called, but they researched the femicide, intimate femicide, so the women killing men and compared to homicide of men killing women. And what they found was that as women have had more opportunities to leave, whether it's because of more financial opportunities or laws or refuges, in fact the rates, so battered women, shelters for battered women, the rates of women being killed has increased and the rates of men being killed has decreased. So as women have options to leave, obviously we all know that working in the area they do that, but that we know that often when women leave they're at greatest risk and the men come after them, and many women are killed in that process. But conversely, if women have the opportunity to leave and don't have to defend themselves, they don't. Whereas women who leave, or as women have more opportunities to leave, it threatens men's control of those women, and so the rates of women being killed actually goes up. So, and yet we see things like the provocation exists, so that if a man kills his wife or his girlfriend or a woman he's been dating and says, oh, I killed her because she provoked me, there's nobody there to counter the evidence. And courts, predominantly male judges, have accepted things like, oh, she belittled my sexuality or she laughed at my penis. And in fact, in Canada, we've started calling it the weenie-peenie defense, because the only evidence is other than the man's is the woman who's dead. And yet I don't know of any cases where a woman has been able to use provocation. And you'd think that being beaten up, if any, we don't support using provocation anyway, because it's only partial. It only allows you to then plead to manslaughter. We already have the problem of most of the women plead guilty anyway. Most of the women provide all the evidence.
Same with here, and because here, murder, which is what the women we charge with, the penalty is mandatory life. So there's no negotiation about a sentence, or no mitigating factors can be taken into account. So it's a straight mandatory life sentence. So what happens is that I find for a lot of women, even if they've got a really good case, for example, of self-defence, which is a total defence, and maybe even provocation or the battered person's defence, is that women don't want to take the risk. Because, say, with the new battered person's defence, the onus is then on the defence to prove. So, which means that the woman has to get in the witness box and give evidence. And sometimes women have been so abused that it's just re-traumatising again, and then they get attacked by prosecution, basically trying to discredit them, and that gets played out in front of a jury. So a lot of women, because of the risk of a jury finding them guilty of murder and being mandatory life, they will plead to manslaughter. So it doesn't even get played out in court.
That's right.
In front of a jury, to put all the evidence there, because then they plead, and then the only evidence that prosecution puts up really is what's in the evidence against the woman, which they're using anyway, and then defence may use some mitigation, and it just depends on your defence lawyers how far that goes.
Mm-hmm.
Yeah.
Well, and that's exactly right. The same thing happens in Canada. In our mandatory life sentence, there is no mitigating factors. I mean, if you get if you're convicted of first or second degree murder, then you're in life.
So just explain, we don't have the differing first and second.
So first is planned and premeditated.
Yep.
And second would be murder, where it's clearly murder, but it may not have been planned or premeditated.
Right.
Well, many women are first charged with first-degree murder because they'll say, yes, I waited till he was asleep, because if they had actually defended themselves while he was awake, they'd likely end up dead. And so many of them get charged with first-degree murder. And if there's evidence of abuse that the Crown becomes aware of, almost invariably, they will offer a plea to manslaughter, because they know that then there's huge pressure on the women, because sometimes the lawyers themselves, I've had so many lawyers who have said, well, it's not really self-defense because she stabbed him when he was asleep. And I said, but if she had waited for the attack to happen, she might have ended up dead. And so a lot of them, especially the male lawyers, can't even get their heads around it. Some of the women too, but especially the male lawyers can't even get their heads around that this is not an attack, a predatory act or attack, planned premeditated murder. It is a preventative intervention to try and prevent him from killing them and or their children. And a lot of women don't act until the children are threatened. And most of the women we're working with, they've acted after their children are threatened. And so we end up with women having lawyers who are saying, oh, you better plead guilty. Most women don't want to, it's not just facing the life sentence, is if they're mothers, usually the only other witness to the abuse is their children, and they don't want to have their kids be put on the stand and harassed, and they don't want to have their, the likelihood of them getting a life sentence and end up in custody for even longer, so the separation of their children. And the other thing that happens, it is the only area in law in our country where you see that kind of attack on the person who would otherwise be the victim in whether it's sexual assault cases or violence against women cases. Imagine, I often use the example in the law class of, imagine if we treated any other victim that way, the way we treat sexual assault victims or victims of violence against women. And they'll look at me sort of weird, and I'll say, well, just imagine, my house was broken into, my house has been broken into a couple times, but, let's say, use one example. My partner just bought a brand new TV. We had a brand new TV, and the TV was stolen. There was other things stolen, but that was the main thing stolen. And so imagine if, the police hadn't believed that we really had a stolen TV, and then the Crown didn't, but they agreed to run the charge anyway because, it's supposed to be mandatory charging for break and entry into homes. And so then I get put on the stand, and imagine if the line of questioning went the way it does for sexual assault or violence against women, and they say, isn't it true, Ms. Pate, that you just bought a new TV? So you were flaunting you had a new TV. And isn't it true you often invite people in to watch TV with you? Well, yeah. Isn't it true you usually leave your house unlocked? So you're really inviting people to come in and see your TV, watch your TV, maybe even take your TV. And even worse, you really flaunted it because on garbage day, you put out the box to be recycled and showed everybody you had a brand new TV. And you have curtains on your windows? Well, yes, or a cover. And you leave your curtains open? Well, yes. So you flaunt it. What do? You just show off that you've got a TV and you flaunt it, and you're inviting people to come in and take your TV. People laugh, and the students laugh, but that's exactly the way we treat women who have been abused or assaulted. And essentially say, it's your fault, and we don't hold responsible the individuals. If I walk around naked, it's not an invitation for a man to rape me. If I'm in my home and I invite someone in to have a drink or to watch TV, it doesn't mean I'm inviting them in to rape me. And yet we don't apply the same standards.
No, the same line of questioning would be applied. That's right. Yeah. I suppose the thing that I'm interested here is because some of the great work that you've been doing and your organisation in Canada is actually intervening around these types of cases that end up in court where women are charged, which is unheard of here. It's something that I'm very interested in, and I'm sure others would be very interested in. where you come in and get standing to appear to then assist the judge or judges. So you're not actually defence, you're not prosecution, you're actually independent in your own right. Can you just talk about some of that work?
Sure. I mean, we did that in the Ryan case that I was just talking about, that we felt that there needed to be a better analysis of the equality provisions, or the inequality of women in those situations, and so we applied to the court for standing to appear to be able to present a different perspective. We usually do that at the appeal level, but we have tried, not always successfully at the trial level, to argue to a judge that they should hear why in fact they should not be accepting a guilty plea, and why in fact they should be asking for more evidence about the context in which violence has occurred. And so we worked closely with rape crisis centers, battered women's shelters, and women's centers, really, advocacy centers, to develop those analyses. And sometimes, if we don't get standing, we still will appear. And the way we appear is, I might get called as a so-called expert, or somebody else working in by defense in a shelter, or in a battered women's shelter, or rape crisis center might get called to give evidence as part of contextualizing. If we can't even get in there, then we'll actually band together and we'll all show up in court just to make sure that the lawyer, the judge, the prosecutor, everybody knows that the women's community is watching what they're doing in prosecuting this woman. So we've had a couple of high-profile cases that have become high-profile, not because they may have been to start with, but because we've done media and actually raised it. So it's at those different levels. So if we get into the court, we go into the court. If we can't get access to the court, either at the trial level, sentencing, or appeal, sometimes we're denied all of those, then we'll still do media around it and try to draw attention
and have
to
action by being in the court.
Yeah,
so
actually physically appear in court.
All the men, and it's traditionally men, because especially around criminal defence law, it's pretty well, law in general is pretty well infected by white men. So that would have taken a long time, though, to say, for example, educating defence lawyers to call you as an expert, because it's a rarity that we do that. The experts that I think traditionally called here are usually like forensic psychiatrists. It's my experience as a criminal defence lawyer as well, is it's very hard to find a good forensic psychiatrist that has an analysis around violence against women.
Yeah, we've had the same experience, and it's certainly been a long process of developing those, and we're not always successful now in terms of getting access, and also trying to educate the psychiatrists. So we try and do work with not just the lawyers, but also psychiatrists. And I mean, a good example is just while I've been here, yesterday in fact, I had a message from a man who has a friend who was raped by a firefighter in our community, and when she went to report it to the police, they're all friends, and there's been no investigation. And so
similar to the Ryan matter.
Yes, very similar to the Ryan matter. And so in this situation, I'm here in Australia, so it would be hard for me to personally intervene. But in any event, I thought, I know who to call, and it's a woman who actually went to law school. That doesn't matter for this experience, this example, but she's a woman I know because she went to law school and because we worked together. And I called her up and then sent a follow-up email saying, look, this is the situation. I've given your name and number to this person, and I think you probably know who to call in the police because she works in that area all the time. And this woman is having trouble having her, having her case even looked into. And I got an email back this morning, and she said, "Oh yeah, I know exactly who to call. So I'll look forward to. Thanks for the heads up. I'll look forward to getting her call." Now, if we hadn't developed those relationships, and if we didn't, hadn't done some of this work, I might not know who to put her on to. But now, that woman will have the assistance of someone else to push with the police to even lay the charge. So this is a case where she's been raped and nobody is taking this seriously.
And that type of advocacy and agitation work is really important in regard to not just the individual cases, but the systemic issues of violence against women. And I suppose I'm wondering how we can encourage, women in the area here to be more active that way. A lot of times it's because lack of resources, or they're just focused or can only focus on service provision, so supporting the actual woman who's either trying to get a domestic violence order or going through court, or then she's been criminalised and going through prison and release. But I mean, I see the domestic violence sector and family violence sector and the sexual assault sector for that matter very focused, I think, because of resource limitations of that, just the day-to-day grind of service provision, where I would like to see some more collaborative work around the broader issues so that we can call on each other when this happens in communities, and it happens all the time. You know, there was a woman charged this morning in court for murdering her partner.
It'd be unlikely there's not violence there somewhere in our experience.
As soon as I heard that they charged the partner, exactly. And we don't know what the evidence of that is. It's an allegation, obviously, against her at this stage, but I'm sure, there will be, maybe at the end of the day, that's if lawyers go down that road, the exposure of the violence. But we see it all the time, and I think it's about how do we here in Queensland encourage other Queensland women who want violence against women stopped to work in that broader systemic context.
Well, it's part of it's awareness, and I think the fact that this sort of educational activity is happening is really important, because when I first started trying to approach women's shelters and rape crisis centers, a lot of them had no interest in, because they say those are women who are criminalized, they're perpetrating violence, they're not who we work with. And so there's no doubt it's been an education process, and we've had a few of the organizations that I don't think it's accidental were also the rape crisis centers and battered women's shelters that resisted government control and government resources for a long time, who were the first to come on side, and some that still won't work, won't take women in if they've ever been convicted of a criminal offense, are ones who are very much linked to police-based victim services. That's not to say discredit, they do their work, they do a good job, but the reality is the more that dichotomy is one that is encouraged by the state, not discouraged. And so we've done a lot of work for a couple of decades now to try and overcome that. And it's not universal. I mean, there still are some shelters that won't work with the women we work with, because once they've been criminalized, they say they're no longer victims. We don't accept that analysis, and fortunately, most of the women working in the violence against women sector don't either. But that's certainly an issue, and I can understand that if there's and particularly if there's been a lot of money, and I think I'm not sure about Queensland, but I know in some of the other states there's been a lot of government money injected into victim services, and with that usually comes all kinds of strings attached to what you can and can't do, and what you can and can't say. And if that's true, then it's hard. Then what I usually say to those sectors is, if you know it and you feel you can't say it, then make sure we know it so we can say it and do something about it. And so we've developed some good partnerships that way. But it's an ongoing issue, because and yet it makes sense the minute usually you talk to people about it, that of course it's a continuum, and as we're seeing more crackdowns on so-called law and order and backlash to women, it's impacting women's equality across the board. And so it is an issue that we all, as women's groups, all have to work together on.
Sometimes I get frustrated, lots of times I get frustrated with some women that work in this sector and they're working in these areas, that the catch cry now has been for some time is, but what about the men? And so it's about having, I think, a deeper analysis to understand about inequality for women still, because and that's been a political push as well. What about the men? The men suffer too. What about the men? The men need programs too. What do you say about that?
Oh, well, I say it's always been about men. And of course we expect them to say, what about men? And not.
But these are women working in the violence against women sector.
Yeah.
We have that
we do have that too. I mean, again, it tends to be more government-funded groups who are getting a push to say, well, there's men who've been abused, and that's true. I mean, when I worked with young people, it was very clear the rate of young men or boys and girls being victimized was much more equal. But you see it change as they age, because it's a stereotype, but it's a truth. Stereotypes often are rooted in some truth, but the reality is that most of the men who have experienced violence, sexual and or physical abuse, often tend to act that out and often become perpetrators. Women, on the other hand, tend to, they may end up criminalized, but not usually because they've gone out and been predatory in their acts of violence, but because they may use violence themselves in reacting to the violence they experience. It's very different scenarios. And so I would never say don't deal with the men, but I would say to a woman's service, why are you dealing with the men? You should be focused on supporting the women, and there's lots of services for men that should be providing that service, and in a way that holds men accountable for their violence. I mean, too often the services provided for men actually reinforce stereotypes of women as somehow deserving what they get. I mean, I remember when I first started doing work with male sex offenders, because I made myself work with male sex offenders for a period of time to get past my own block on that issue. And what I found, and part of the reason I stopped doing it, is because many of the people working in that sector were actually, even if it was unwittingly, reinforcing the stereotypes of, the bad mother, it was having a bad mother. I mean, the mother was the only one left standing with those kids. And she may have been being violated, and she may have been using force against her kids. That doesn't mean that that's where it started. And yet there's a lot of, encouragement of men who have been abused to blame the mother for not protecting them, as opposed to the absentee father or the violent
No,
dad.
it's always a woman's fault.
Yeah, and so
responsible lives about everything.
yeah, well, and the hyper-responsibilization of women. So I think there are certainly services. I would be the last one to say, of course, you have to have services for men as well, but not the same services. And you certainly should be looking at the fundamental inequality that women experience at every level: social, economic, criminal. I mean, women are the fastest growing prison population. I've yet to have a person say to me, when I think of who I'm at risk of when I walk out on the street, I'm afraid of women. I'm especially afraid of poor women, and I'm really afraid of Indigenous women, and I'm really afraid of women with mental health issues. Nobody says that.
No, that's right.
No.
But they're the ones that are the fastest
They're the fastest
growing
growing
population, and here in this country. Yeah. And here now in Queensland, like there's just yesterday, there's 70 women, extra 70 women in the local prison here, overcrowding and rising. So we've gone from under this new political regime that are here at the moment in Queensland, in Parliament, we've gone from a 6% of women's population out of the total population to 10% now. So, and that's in less than 18 months, and it's forever growing too. And there's a whole lot of issues around what that is, because they're repealing laws and a number of issues there. But yeah, it's hard. And I think the other thing that we have is governments that are now telling women's organisations that you have to provide services to men with the same amount of money too that you had. So women's services are being cut, men have to be included, and it's about this, I hear organisations say, well, we have no other option because we've got to have the money. You see, well, our stance at Sisters Inside is particularly around, because we thought that it would come around our sexual assault funding, because the sexual assault sector has been told that they will have to work with men. We will not accept the money. We will relinquish the contract and hand it back because we just don't work with men, and not because men don't need to be worked with, obviously, but we're a women's organisation for women, by women, with women, and we won't accept government money at all. And it's interesting because you've got those services, the rape crisis DV services that are independently funded, where we don't have that situation here.
Yeah. Well, and it's a much smaller group now, because the more people rely on government funding, the fewer options there are for fundraising in those other areas. But there certainly are. And there are some who, even though they accept government funding, will stand up. And we had a really good example in Ontario of the Association of Interval and Transition Houses. So they work with battered women, all standing up to the government as a group and saying, no, you can't be imposing these. And the government eventually backed down. I mean, one of the challenges is we're often, encouraged to be divisive amongst ourselves, and that's, obviously counterproductive. And so they've managed to stay and, argue that collectively. And as with anything, if you can stick together on things, and they need the services. They know they need the services, and so eventually they'll back down in our experience. But But yeah, there's a lot of pressure on to move away. And, you know, in whose interest, you know, what we usually say is in whose interest is it to accept that analysis? Well, it's not in women's best interest, and it certainly is more in the interest of the state to absolve itself of responsibility. So if women's groups are being asked to provide services for women with inadequate resources and then add it to it, provide services to men still with inadequate resources, and then if women aren't protected, well, it's not our fault, the state says.
That's right.
It's, you know, these women, these groups who are supposedly responsible for violence against women aren't doing their job. And so I think it feeds that whole notion of, you know, the state as retreating from their responsibility to protect.
Oh, we're seeing that around a number of areas, you know, like the privatisation of so many areas and the retreat of the state. Yeah, and you're right, and so then it's about, well, we're doing this and you can blame them now. So they become 1 or 2 steps removed and don't have to be accountable for any decisions. Yeah. And it's a sad day for women.
It is, it is. I mean, there's a piece that we did with the Native Women's Association in Canada, and some of the anti-violence sector was involved as well. And it's a piece that's in our Canadian Journal of Women's Studies that might be useful for some of the folks. It's called the hyper-responsibilization of particularly Indigenous women and girls, and focuses on that whole area.
I suppose what I'm interested in is, because we do have a sector that's active, that women do, well, not all women, it's probably a small percentage actually engage with services that have been victims of violence, both sexual and physical. I suppose I'm interested about what is it and how does your organisation, and what is it that's important for workers at the grassroots levels to be supporting women who are victims and, for that matter, survivors of violence?
Well, one of the first challenges we had was often finding places for women to be when they were leaving. So the obvious is if they're fleeing a violent situation, a home, are there rooms in the shelters? Oftentimes they're oversubscribed, and so finding support there. We've actually had some of our shelters, our battered women's shelters, assist with getting bail, and our rape crisis centers assist women who have been charged with defending themselves, help them get bail, and so they have a place to stay, and they've stayed in the shelters, which, you know, was seen at first as, how can that be happening? Someone who's facing criminal charges is in our shelter, but, you know, after working with them, and a number of them have taken.
And that's a really important piece, and it's a piece that we do at Sisters Inside. So I would hope that those organisations, the shelters, and where the women are, or they know one of the women that they've been supporting has gone to prison for a violent offence, can contact us, because we have a bail program that's free, because it costs about $5,000 to $10,000 for a Supreme Court bail application here for private lawyers to do, but we actually do that with, you know, where I lead that with law students, and we've had a 100% success rate to get women out. So it's a really important piece of work that the sector hopefully uses for women in the future. You know, they can refer to us. Yeah.
And I suspect most shelters that or refuges for battered women will know of women who they've either known in the community or provided support to, who may have been charged at some point, especially since with the mandatory charging policies. Yeah. And sometimes they've been encouraged to develop policies that say we never take anybody who has used violence, and to be able to contextualize that and say, hang on a minute, it's a different scenario of someone using predatory violence, going out and attacking someone, versus a woman reacting to violence with, you know, sometimes having to use violence to protect herself or her children. And the other place is sometimes we've had women come out of prison where there aren't, you know, virtually no accommodation supports, and been able to access shelters or battered women. And in two contexts. One would be we've used it for women who are coming out on parole, and so again, someone who's coming out essentially serving their criminal sentence, ending up, you know, serving part of the parole period in a shelter, and supported by anti-violence workers, and supported by getting counseling for the sexual abuse she may have had historically and more immediately related to the charge. As well, we've had some provide support, particularly shelters that focus on Indigenous women, but also other racialized women who are facing deportation, who've been able to provide support pending applications to be able to keep them, seek
Yeah.
asylum or
Yeah.
keep them in the States or in the country. So those are some of the places, and those sorts of supports are really important. And we've also managed to get some women out of prison, very rarely, but on passes when they're getting close to their release dates, to go for sexual assault counseling. And I know you provide sexual assault counseling at Sisters Inside.
Yeah.
Some of our members do too, but in areas where there aren't any, we actually have made arrangements so women go out and go to a local rape crisis center, sexual assault center, or
we have that available in the low security prison that's over in the north side, that women can get a pass to attend counselling, which is great. It's only just a new thing.
So that would be great if they can access, if it's an area where Sisters isn't available,
That's
to
right.
be able to access some of those other services, so that would be great. Yeah, so those are some of the things I can think of off the top of my head. On occasion, a woman who has pled guilty to manslaughter, and if it doesn't involve, in our country, if it involves a weapon, there's a mandatory minimum. Historically, there wasn't. And there was a woman who, while she was awaiting trial, began to get support from a rape crisis center and battered. They both had a rape crisis center and a battered women's shelter in the same anti-violence against women service. And one of the things they did was assist us so that, in addition to providing some expert testimony about the violence, the context of her being charged with first murder and then prosecuted for manslaughter, in that process they were able to not only put in context the violence she experienced and why she had reacted. In her case, she had killed her psychologist husband. Well, he was a police psychologist husband, so he constantly threatened to kill her and her children. And the night that she shot him with one of his own guns, he had raped her outside their daughter's door and had threatened to start raping their daughter. Now, the threat that he always used against her is if she ever tried to leave, he would kill her and the kids, and he said he had the entire house wired with explosives. Turned out she didn't know that was true. After he died, they took out tons and tons of weaponry that were totally illegal, but he had one. And secondly, they found that he had in fact wired the entire house with explosives. She didn't know whether that was true or not. She believed that he was capable of it, and he had done that. And you know, that there were attempts to try and hide that. He was a police psychologist after all, and there were all kinds of attempts to characterize her as evil and, you know, having gone after with doing it. Anyway, in that context, not only did she get support, counseling support from the shelter, she later, it was used as one of the reasons why she should be given a home detention order instead of a prison sentence, so prison in the community, and that she would continue to get support from that center, but also would it would be a way for her to continue to do her work. And in fact, she's now an advocate for battered women because she got that kind of support and was able to serve her sentence in the community. And you know, that's a tremendous assistance to women and their children, obviously, if they can access those kinds of services.
And alternatives, which we don't have here. And once again, the political landscape is such where the government's repealing more and more alternatives to sentencing. So we're pretty much going to end up where it's straight prison, well, manslaughter. Manslaughter, you'll do time anyway, you know. I think if I can say the best outcomes is for, I can think of one young woman, she was 17, 18 at the time, was living with her partner for a number of years, since she's been about 12 years, horrendously violent, and he'd attacked her and just grabbed the knife in the kitchen and one stab wound, and he died. We worked with the lawyers, the defence lawyers, very closely in exposing and getting the material, the evidence for them to really detail the violence, and even from his own mother, and which was quite powerful. And anyway, she was originally charged with murder. We got her out on bail. She ended up pleading to manslaughter, and she got, it's probably one of the best sentences in this jurisdiction. She got 5 years to serve 12 months. She's been out now for a long time, but I mean, she was just so traumatised, and for someone so young to be so traumatised like that, like I remember You know, we spent a lot of time together, so going to the shop to get lunch, for example, and I'd say, what do you want? I'll buy lunch, what do you want? And she said, oh, just get me what you want, what you're going to get, right? And after about a few days or something, I'm thinking, this is weird. It's finally twigged, just get me what you're having. And so I said, no, I want you to pick something. You can't be wanting what I want, because you won't like what I've got. Because I was buying, at that stage, a grated cheese and a grated carrot sandwich. And I'm thinking no one else would want that. So it's like, yeah. And she couldn't make the decision. Like, that's how, you know, traumatised she was. And so then it was about encouraging her to just make those little decisions about what drink do you want, what flavour drink, what do you want on your sandwich, and had to start all over again. Mm-hmm. It was really sad, but, you know, she's doing really well now, so that's good. Mm-hmm. And, yeah, but, I mean, in regards to manslaughter, well, definitely murder's life, manslaughter, you know, the average sentence these days is around 8-10 years, so, mm-hmm. Yeah, with, you know, 2, 3, 4 years to serve, depending on the mitigation.
Well, and the other thing that I think is really important, especially, we've got similar, I mean, the woman I was just talking about now, there's a mandatory minimum sentence if you've used any kind of weapon, and so she would not be able to get that home detention order anymore, and so one of the things we do now is try and get as much media attention before the woman even ends up in at trial, and to try and help contextualize what happened. And I know a number of people in Canada believe that's why in the Ryan case she wasn't sent back for a new trial. Yeah. And in fact there was a stay of proceedings. It's, you know, it's not the most courageous move of our Supreme Court of Canada, sure. But certainly it meant that she didn't have to be re-traumatized by another trial. Yeah. But you know, it's, and we did that really by using you know, using our coalition work to try and get as much media attention as we could. So.
Well, it's been great speaking to you.
You too.
Thanks for having this conversation and providing all your knowledge and expertise for the sector here. And I'm sure it'll be well received, and there's some great ideas in there that we can actually take on board and move forward, hopefully to eventually stop violence against women, because that's the aim, no doubt, for all of us. And, you know, with equality in mind.
I agree. So thank you for inviting me, and thanks for all the great work you're doing here.
Thanks.